Good afternoon, everyone. My name is Brad Phillips. I'm a partner at Wagner Sidlowski LLP and the co-chair for this Lunch and Learn series on strategies, advice, and the elderly, along with Peter Neufeld. The subtopic that we are speaking about today is about power of attorney issues. A paper was prepared by Anna Fox and me in advance of today's seminar on this topic, and a PDF copy of the paper can be found in the Zoom chat. The certificate of attendance will be posted in the chat momentarily for you to download. The seminar has been approved by LawPro for Risk Management Credit Program, and it's eligible for a $50 credit claim. Thank you to our sponsors, Scotia Wealth Management, the B'nai B'rith, Consenter Trust, Weirfold LLP, Donovan Kochman LLP, and Torkin Mains LLP. This event is complimentary because of them. Just a few housekeeping notes. Please have your microphones muted at all times unless you are asking questions at the end of the presentations, after which we ask that you mute yourself again. Please also know that this seminar is being recorded. We have three presenters today. I will be speaking, as will Yana Fox and Lisa Saad. Lisa Saad is a founding partner at Saad Estate Law and practices exclusively in the areas of estate and trust litigation. And Yana Fox is an associate at Wagner Sidlowski LLP, practicing in the estate and commercial litigation groups, and who graciously prepared a paper with me for today's presentation. If you enjoy our seminar, we ask that you consider making a donation to the B'nai B'rith Canada Food Program if you haven't already, and the link for that is in the chat. Cheryl Landy, the Director of Community Engagement of B'nai B'rith Canada, is here with us today to tell us a bit about the organization and its charitable work. You have the floor, Cheryl.
Thank you, Brad. Hello, everybody. My name is Cheryl Landy, and I am the Director of Community Engagement at B'nai B'rith Canada. For 2 decades, B'nai B'rith Canada has proudly partnered with Wagner Sidlowski's CLE programs. We are truly grateful to our long-standing relationship with your firm and for the meaningful contributions you continue to make to the legal community. Your support helps us continue to do the work that we care so deeply about. As many of you may know, B'nai B'rith Canada is the country's oldest human rights organization. We're dedicated to fighting racism and hatred in all its forms, advocating for the Jewish community, and supporting some of Canada's most vulnerable seniors, those living in poverty, and people who are often isolated or alone. When people ask me what B'nai B'rith does, I tell them this: we defend, we care, and we lead. In previous visits with this forum, I've shared stories about our food bank, our affordable housing program for seniors. I've talked about our clothing giveaway program, which brings warmth, dignity, and joy to hundreds of families, and our men's program, which builds community for those who feel alone. Today, I'd like to share something a little different, something that brings together 2 generations in a beautiful way. We've launched a volunteer-led initiative that brings Jewish values of kindness and community into schools. One of the most heartwarming programs that we've created called Tuna Tuesdays. Here's how it works. Students in participating schools compete in their school houses to collect the most cans of tuna or sardines. The competition is fun and spirited. Kids love the challenge, but behind that fun is something powerful. That tuna becomes an essential part of the food boxes that we deliver each week to seniors who are facing food insecurity. To the students, it's a game. To us, it's a vital source of protein for our food bank. To our seniors, it's a reminder that they're not forgotten. At the end of the school year, the winning team gets to deliver the boxes themselves, meeting the people whose lives they've touched. It becomes so much more than just a project. It becomes a moment of connection, of understanding, and of shared humanity. These same students also take part in two special holiday programs for our affordable housing residents. For Hanukkah, the Festival of Lights, and Purim, the holiday celebrating Queen Esther's bravery and the survival of the Jewish people, the children create thoughtful gift bags filled with treats and essentials. Just before the holidays, they hand deliver the bags to the seniors, bringing joy, excitement, and the kind of energy only children can bring. For many of our seniors, it's the highlight of the year. At B'nai B'rith, we don't believe in just giving handouts. We believe in building meaningful experiences that empower people, young and old alike, and remind them that they're part of a caring community. Thank you again for welcoming me here today and for your continued support of B'nai B'rith Canada. I look forward to coming back and sharing more of our stories in the months ahead. If you'd like to continue the work, please, as Brad said, the link is put in the chat at bnaibrith.ca/donate. Your support will help us provide not just clothing or food, but compassion, connection, and hope. Thank you for standing with B'nai B'rith Canada.
Thanks for that, Cheryl. Okay, let's start with the seminar. First to speak will be Yana Fox, who will be reviewing some of the fundamental concepts behind powers of attorney, including when a POA may come into effect and the fiduciary obligations of an attorney. Next, Lisa Saad will be reviewing how a third party may bring an application for the removal of an attorney. And finally, and pardon the very intentional World Series reference, I will be batting cleanup and discussing another potential method for having an attorney removed and how a passing of accounts can be a potentially important tool in pursuing the removal of an attorney. So without further ado, Yana, please take it away.
Thank you, Brad. Good afternoon, everyone. As Brad mentioned, my name is Yana Fox, and I am an associate with the firm. Before we turn to the specific cases where courts have removed attorneys, I want to set the stage by walking through the legal framework that leads us to that point. Essentially, how do we get from concerns about the conduct of attorney to a court-ordered removal? So this process starts with understanding the authority under the Substitute Decisions Act, also referred to as the SDA, and the common law fiduciary obligations that underpin every power of attorney relationship. So just to back up, a power of attorney is a legal document that grants person B the authority to make specific decisions on behalf of person A, and typically concerns finances or healthcare. Despite the name the attorney, it does not need to be a lawyer. So once the attorney starts acting under a power of attorney, they step into a fiduciary role. So in other words, they're not just helpers, they're people who hold legal authority over someone else's money or personal care. And as Mary McGregor summarizes in Preparation of Wills and Power of Attorney, a fiduciary must use reasonable care in acting, must not obtain secret profit, must account, must not allow personal interests to conflict with those of the principal, and most importantly, cannot make, change, or revoke a will on behalf of the donor. Now, further duties can be found on page 4 of the paper. These are just some that we have highlighted for the seminar. So when a family member or a beneficiary starts noticing red flags like large withdrawals, isolation of the grantor, or sudden changes to the care arrangements, those fiduciary obligations are what brings the matter under the court scrutiny. Now, once an attorney is appointed, an attorney's authority can end in a few ways. They can either resign, the grantor can revoke the power of attorney, or a court can remove them. I will focus on the revocation route because that's the first opportunity for the grantor themselves to make a change before litigation even begins. Now, if we take a look at Section 8 and 47 of the SDA, a person is capable of revoking a power of attorney if they're capable of giving one. So even if someone has started cognitive decline, they may still have enough understanding to revoke and appoint a new attorney. So for a continuing power of attorney for property, so an attorney that deals with property, the threshold is actually quite modest. Some of the things the grantor needs to know is what property they have, what the attorney can do on their behalf. They must understand that the attorney must account and that the attorney's authority can be revoked. So that's the test with respect to the continuing power of attorney for property. Now, for a power of attorney for personal care, the test is even simpler. They just need to understand whether the proposed attorney genuinely cares for them and that they may need that person to make decisions. So this is an important distinction because it means the capacity to revoke isn't automatically lost when someone is deemed incapable of managing property or care. So long as the individual meets the narrow tests that I've just discussed, their choice to remove an attorney will stand. Unfortunately, in real life, it's rarely this straightforward, and it's often the case that the attorney being removed may argue that the grantor no longer has the capacity to make the decision, or that another family member is exercising undue influence on the grantor. And that's when evidence becomes key. Practitioners often recommend obtaining a certified capacity assessment from a qualified assessor to confirm that the revocation was validly made. So having that assessment in the file not only protects the grantor's choice, but it also deters challenges and can prevent a later motion for yet another assessment. So this step often resolves the dispute without ever having to go to court because it provides clear evidence. But sometimes the grantor's decline is too advanced. They simply don't have the capacity to revoke or appoint a new attorney. So at this stage, the family members or the public guardian and trustee may have no choice but to ask the court to intervene. And that's where we move into scenario 2, when a third party brings an application for removal. And I will let Lisa take over and discuss that part.
Great. Thank you, Yana and Brad, as well for the introduction. So as you just heard from Yana's presentation, and you're probably aware that attorneys act in a fiduciary role, and so they're expected to manage the grantor's affairs with honesty, integrity, diligently, and in good faith for the benefit of the grantor. And so when these red flags that Yana alluded to rise, or when there's a breakdown in trust or that relationship, then there's a question of whether or not the court should intervene to remove an attorney for property or personal care. So the court has authority to give directions on any question arising from anything in connection with a guardianship or power of attorney. And so that's usually done through an application for directions. And an application for directions can be made by various parties. That can include an incapable person's guardian, one of or either power of attorney for property or personal care, one of their dependents, the public guardian and trustee, or any other person with leave of the court. The court can also terminate a power of attorney during an application for passing of accounts, which Brad will talk about passing of accounts during his portion of the presentation. And the court can also appoint a guardian of property or personal care for somebody who's incapable, and that appointment would terminate any existing power of attorney. I do note, though, that guardianship is considered a last resort by the courts, and so the courts will not appoint a guardian if the need for decisions can be met by a less restrictive alternative. However, when we're dealing with an incapable person and an attorney needs to be removed, that usually is one of the ways that somebody else is appointed, because usually in that situation, someone does need to be appointed to make decisions. So talking about grounds for removal, so courts are generally wary of terminating a power of attorney granted by a donor with capacity because they want to respect that donor's wishes unless it's no longer in their best interests. So it is a high bar to remove an attorney for property or personal care, and you do need strong and compelling evidence of misconduct or neglect on the part of the attorney before a court will ignore the clear wishes of that donor and terminate the power of attorney that presumably they made when they were capable. The test for removal is two parts, and it was recently affirmed in a Court of Appeal decision that was cited in the paper. And so the two-part test is one, whether there is strong and compelling evidence of misconduct or neglect, and two, whether the attorney is serving the incapable person's best interests. So while the threshold is high, as I mentioned, the courts will intervene when an attorney's conduct shows a serious breach of fiduciary duty. So what are breaches of fiduciary duty? So in the property context, when we're talking about an attorney for property, that person owes a fiduciary duty to the donor. And when the donor is mentally incapable, that attorney's fiduciary responsibilities are actually held to a higher standard and closer to that of a trustee. And the onus is on the attorney to demonstrate that any funds or finances being managed, assets being managed on behalf of the donor, belonging to the donor, are used and managed for that donor's benefit. Again, especially if the donor is incapable. So examples of misconduct that can lead to removal include financial misappropriation, using the incapable person's money for the attorney's personal benefit, failure to provide regular accounting, failure to voluntarily pass accounts, failure to provide missing information or documents for missing funds, commingling funds, and even things like an inability to follow court orders could be grounds for an attorney's removal. And the court has inherent jurisdiction to remove attorneys where there is a breach of fiduciary duties. Every case is different, so these are just some examples, but it is a very fact-dependent and fact-heavy analysis generally by the courts. When we're talking about personal care, so attorneys for personal care must act in good faith. They must make decisions in accordance with the Healthcare Consent Act. And the Substitute Decisions Act, they are required to foster regular personal contact between the incapable person and supportive family and friends. They're required to consult with the family members and caregivers. And so misconduct in this scenario can include failing to act in good faith, refusing to approve necessary expenses for personal care, failing to make required or timely treatment decisions, failing to foster regular contact with supportive family, failing to consult with caregivers. An attorney, as mentioned previously, can also be removed if they're no longer serving the donor's best interests. Another ground for removal is animosity or inability between co-attorneys to cooperate or to act in the donor's best interests, and that can also lead to removal. So in the paper that you received, there were several cases cited in there talking about instances of removal. So I'll just talk a little bit about the case law and the different scenarios where attorneys have been removed. So the first case I'll talk about is the Christmas estate case, which is a 1995 decision. That was a case that dealt with gifts that were made by the attorney to themselves. The court said in that case that gifts are presumptively suspicious when they're made during incapacity and will attract heightened scrutiny by the court. And that case illustrated that even when there's no misappropriation of funds, any perceived self-benefit or conflict of interest may justify court intervention, oversight, or in more serious cases, removal of the attorney. And so this goes back to that obligation to act in the attorney's best interest and not to self-deal or derive any benefits from that role. Another case is the Belfoyle v. Belfoyle decision, which is a 2018 decision. And in that case, it was a daughter who was acting as her mother's attorney for property, and she deposited her mother's funds into her own personal bank account, used her mother's money to purchase items for herself, including household appliances, created false health concerns relating to her mother, and failed to comply with a prior court order to provide a full accounting. And so that was the case where the court found that the attorney had clearly fell well below the conduct, or excuse me, the standard required of somebody acting in that role, and terminated their power of attorney. Another decision is a 2024 decision of Bogue v. Bogue. This was a bit more unique in the circumstances, in that there was no misappropriation per se, but there was an attorney whose personal beliefs and family conflicts derailed their ability to follow through with their duties and to act in the attorney's best, to act in the donor's best interests. So that was a case where the attorney wanted a portion of the funds set aside for himself for his ultimate inheritance from the donor's estate, and wanted the funds deposited and managed in a credit union account. And so the assets were essentially frozen because there was no cooperation between the two attorneys. And the court found that the attorney's beliefs and fixations on the matters were a failure to appreciate that the donor's needs were immediate, and that her needs needed to be prioritized, and that his personal beliefs were irrelevant to her situation. And what mattered most was she needed access to her funds urgently. I'll talk about two more cases that aren't referenced in the paper, but one of them is Bennett v. Bennett, which is a very recent decision. The citation is 2025 ONSC 4756. So that case, the result wasn't a removal. It was actually a power of attorney document being set aside because there was the presumption of capacity had been rebutted, and there were suspicious circumstances surrounding the preparation of the documents. But the court said that if they were incorrect in that finding, that there was sufficient evidence to warrant a removal. And in that case, the court found that the attorney for property and personal care had failed to comply with their statutory obligations under the Substitute Decisions Act, specifically in failing to foster contact with the donor's family members, with failing to consult with them about his care, and failing to provide disclosure and transparency regarding the management of his finances. And another decision is Aiello v. Bleta, which is a 2020 case, and the citation for that is 2020 ONSC 62. And in that case, the court found that the attorney had not been acting in good faith as an attorney for personal care, as he had refused to approve reimbursement of expenses incurred and expenses for the caregiver, which resulted in the caregiver's resignation. There was a failure to consent to certain surgeries, which demonstrated that the attorney was not making treatment decisions when required or in a timely manner. And the attorney was also not seeking to foster regular contact between the incapable and supportive family members and friends, nor was he regularly consulting with the caregiver. And that was another case in which one of the attorneys was removed for those reasons. So obtaining the removal of attorney is not the end of the road, because as I mentioned before, inevitably you're going to need somebody else to make those decisions on behalf of the incapable person. So usually a removal application will be accompanied by other relief, such as a declaration that an earlier power of attorney document is valid and should be in full force and effect, or the appointment of a guardian for property and personal care. And that is a whole other topic that, of course, could be covered under a different presentation. But those are usually the approaches that follow the removal of an attorney. So that I think I will hand it off to Brad now to talk about passing of accounts.
Thanks, Lisa. Before I talk about a passing of accounts, I'm going to discuss another scenario that can result in a change of attorney. And this was alluded to by Yana earlier. And that scenario is when the grantor, or also known as the donor, chooses to revoke the power of attorney themselves and appoint a new attorney. So while generally this scenario may be a simpler process, it too can become complicated. And I say that because it goes without saying that if you are relatively young and you're managing your own finances and making your own care decisions, should you decide to make a change of attorney, that should be a relatively straightforward process. But what we're going to look at here is a more nuanced scenario. So for the purposes of this discussion, we're going to assume that you are dealing with an elderly client whose attorney has been managing their finances for many years. But this elderly client now comes to you, likely accompanied by another family member who is not the attorney, and says they aren't happy about decisions being made in respect of their finances and they want to change. So the first thing that has to be considered is capacity and what that means in the context of the issue before you. Because we already know from this scenario that the current attorney has been managing the client's finances for several years, and that it is likely as a result that the client does not have capacity to manage their own financial affairs. But just because a client lacks capacity to manage their own finances, that doesn't end the discussion. And this is because the test for capacity to revoke a power of attorney and appoint a new attorney is notably different from the capacity to manage one's own finances. And in short, the threshold for capacity to revoke and appoint a new attorney is a lower threshold. And Yana made reference to this earlier, but I'm going to repeat it again because I think it's important. Section 8 sub 2 of the SDA states that a person is capable of revoking a continuing power of attorney if he or she is capable of giving one. And section 47 sub 3 states that a person is capable of revoking a power of attorney for personal care if he or she is capable of giving one. So that doesn't provide tremendous insight, so we then have to go into the other sections of the SDA to see what the standard is if when someone is actually capable of giving a power of attorney. So Section 8 sub 1 states that a person is capable of giving a continuing power of attorney if he or she knows what kind of property he or she has and its approximate value, is aware of obligations owed to his or her dependents, knows that the attorney will be able to do on the person's behalf anything in respect of property that the person could do if capable, except make a will, subject to the conditions and restrictions set out in the power of attorney, knows that the attorney must account for his or her dealings with the person's property, knows that he or she may, if capable, revoke the continuing power of attorney, appreciates that unless the attorney manages the property prudently, its value may decline, and appreciates the possibility that the attorney could misuse the authority given to him or her. So this is notably different from the capacity to manage one's own finances, which requires the person to understand information relevant to making a decision in the management of his or her property, such as paying bills or selling property, or can appreciate the reasonably foreseeable consequences of a decision or lack of decision. And the threshold for having capacity to revoke a power of attorney for personal care is arguably even lower, as the test under Section 47 sub 1 for whether a person can give power of attorney for care to someone is that the person A, has the ability to understand whether the proposed attorney has a genuine concern for the person's welfare, and B, appreciates that the person may need to have the proposed attorney make decisions for the person. So again, this capacity threshold is quite different from the capacity to make personal care decisions, which requires that they understand information about their health care, nutrition, shelter, clothing, hygiene, and safety, and can appreciate the reasonably foreseeable consequences of a decision or lack of decision. But even with this lower threshold for capacity, concerns can often arise in a scenario that I've described at the outset. For example, the attorney who is being removed could allege that the grantor does not in fact have capacity to make such a change, and or allege that the grantor has diminished capacity and is being unduly influenced by another family member, including the one who took the person to the law office, in order to facilitate their removal as attorney. And this leads to some practical guidance for lawyers to consider, both to assist the client and frankly to protect themselves as well. Because ideally, in a scenario where there is an elderly client involved and there is a risk that the current attorney may make some of the allegations I just suggested, it would be prudent to obtain a certified capacity assessment confirming that the client does in fact have the capacity to revoke and appoint a new attorney. And this serves a dual purpose, providing some persuasive evidence to the court that the client did in fact have the capacity to change attorneys at the material time. And it also protects the lawyer who prepared the revocation and new power of attorney. Because if that lawyer was satisfied that the client did have capacity, but elected not to get an assessment done, in the event the original attorney successfully challenged the new power of attorney, the lawyer could find themselves sued by other family members for not obtaining an assessment that would have supported their position in court. And then, as I said, it also serves another practical purpose, which has been discussed in previous seminars, and will also be explored in greater detail during the next seminar. And that is often where the previous attorney challenges the revocation and appointment of a new attorney, they will also seek an order that the grantor be evaluated for capacity. And based upon the case law, if there has already been a recent capacity assessment conducted, a court is less likely to order a further capacity assessment in these circumstances because generally a capacity assessment is viewed as a significant infringement on a person's right to privacy, and the court must weigh this consideration in ordering a further assessment. So if there has already been a fairly recent capacity assessment done, that likely will have a significant impact upon what the court may choose to do if the previous attorney seeks to have a capacity assessment undertaken. So now I'm going to turn for a moment to the issue of a passing of accounts. And that can be the subject of its own seminar. But in the context of seeking the removal of an attorney, the passing of accounts can become a key procedural safeguard. It may reveal to other family members or others that conduct of the type noted earlier has been occurring and will allow the court to scrutinize the attorney's financial dealings and determine whether intervention or removal is justified. So a passing of accounts is just a formal process where a court reviews how an attorney has handled someone's money. It typically involves the attorney submitting a comprehensive accounting in a prescribed form that details all receipts, disbursements, investments, and assets during the period of their management of the grantor's funds. And the process is designed to ensure transparency and allows the court to confirm whether the attorney has acted properly in fulfilling their fiduciary duties. And often when an attorney passes their accounts, they will also seek approval for compensation they may be entitled to for the work they've undertaken. And while an attorney can initiate an application to pass their accounts on their own accord, often other parties want to seek to compel them to bring such an application. So in some respects, it may be prudent to start with seeking to compel a passing of accounts before in fact seeking a removal of an attorney. And for example, a client may have suspicions but no real proof of wrongdoing by an attorney. So to give you an example, let's just say that a sibling is now driving a fancy new car that was purchased just shortly before he, who is also the attorney for mom, sold his mom's home. So is that a coincidence? Did he just win the lottery? or inherit from another family member, or get a promotion for his job. The client may not know that. They just have some inklings or suspicions that it may be coming from mom's money. So if there are suspicions but no real evidence that an attorney may have mishandled funds or acted improperly, the passing of accounts process can become an effective fact-finding tool. The process allows the court and the client to examine in detail how the attorney has managed the grantor's property and finances. And through this review, any wrongdoing, such as misuse of funds, self-dealing, or failure to act in the incapable person's best interests, may come to light. And obviously, if the evidence from a passing of accounts reveals serious misconducts, the result of the passing of accounts may form the basis for seeking the attorney's removal. And in certain cases, the conduct uncovered may even give rise to a quasi-criminal consequences, such as findings of breach of trust or misappropriation, depending on the severity of the behavior. And alternatively, even if a client already has some evidence of wrongdoing, you may well elect to proceed with an application that seeks both an accounting and the removal at the same time, as the accounting may reveal further improprieties that can be relied upon in support of the relief being sought for the attorney's removal. Which then leads to the next question, which is, who can compel a passing of accounts if the attorney isn't voluntarily doing it themselves? And the list of people who can bring that or seek that relief is fairly broad. And it's found at section 42 sub 4 of the SDA, which says that parties who may apply to the court to compel the attorney to pass accounts include the grantor, the grantor's or incapable person's attorney for personal care, a dependent, the PGT, the children's lawyer, a judgment creditor of the grantor or incapable person, and any other person with leave of the court. So I'm going to focus on that last provision in particular, in terms of what any other provision, any other person with leave of the court means. So obviously that's a fairly broad term, any other person. And the leading case from the Ontario Court of Appeal in terms of what that means and whether leave can and should be granted is from the case of Lewis and Lewis, which is found in the paper. It's 2020 ONCA, which cites with approval Ali versus Frucci at paragraph 6, and it states that the test to be applied in determining whether a person should be granted leave of the court under section 42 sub 4 is that the court must be convinced that 1, the person or persons seeking leave have a genuine interest in the grantor's welfare, and 2, a court hearing the application under section 42 sub 1 may order the attorney or guardian to pass his or her accounts. So in respect of that second part of that test, even where a person has a prima facie standing to apply under section 42 sub 4 for leave, it remains within the discretion of the court to order a passing of accounts. And the factors that a court considers in exercising its discretion included the extent of the attorney's involvement in the grantor's financial affairs, and whether the applicant has raised a significant concern in respect of the management of the grantor's affairs to warrant an accounting. So an example in respect of that first factor could be if a passing of account is broadly sought over, I'm making an example, say 10 years, if a court accepts that in fact for 6 of those years, the grantor of the attorney was actually making their own financial decisions and dealing with their own assets themselves, the court may not agree to grant leave to compel passing of accounts going back for the entire time of the attorneyship, but rather only the time where it's clear that they were actually primarily dealing with the grantor's finances. So assuming a passing of accounts is ordered and then subsequently objected to, it is common that issues concerning what, if any, compensation an attorney is entitled to is addressed. And in some cases, there can even be an order for repayment of funds that were taken or mismanaged by an attorney. So for example, in Zimmerman and McMichael estate, where an estate trustee compelled the attorney for property to pass his accounts, the court found that the attorney for property's accounts were inadequate and incomplete, and that he failed to respond to the estate trustee's numerous objections. As a result, the judge drew an adverse interest that the attorney for property had misappropriated funds and ordered him to reimburse the estate for the disputed amounts. And notably, Section 42, Sub 7 of the SDA expressly states that in an application for the passing of an attorney's accounts, the court may, on motion or on its own initiative, suspend the power of attorney pending the determination of the application, or order that the power of attorney be terminated. So again, that indicates that the passing of accounts process in and of itself can result in the removal of an attorney. So I think that's it for my portion of the presentation. And if anybody has any questions, I open up the floor to any questions anybody may have about what we've talked about today. All right, don't be shy. If you have any questions, please let us know.
Hi, my name is Dr. Elizabeth Moore. I'm a capacity assessor and consultant to the Capacity Assessment Office. I'm wondering, it's not quite totally on point, but I know in this day and age, often lawyers are encouraging their clients for when developing a power of attorney document to consider adding in a phrase about the power of attorney document will only begin upon a finding of incapacity of the grantor. But I'm wondering what happens when it's not necessarily anything about the attorney's behavior, but the individual who granted the power of attorney is now feeling that they have regained capacity. I'm unsure of the processes of how that might then work.
So the scenario, if I understand correctly, is that the person has regained capacity. Is that your question?
Or they believe they have regained capacity. But I'm not sure what the process will be. So for instance, with the Section 16 SDA for property, if a person feels they've regained their capacity to manage their property, they can ask for a reassessment or Section 20 out of the SDA. But I'm unsure of the process or procedures with regards to when it's around power of attorney enactment and how that was worded.
Well, I think the process would be largely the same. I would envision that what would happen is if a few things would practically happen. Obviously, if there was a dispute wherein the attorney says, you have not regained capacity and there's still significant cognitive concerns, then the grantor would likely have to retain the counsel and bring an application. And presumably in support of their application, their lawyer would get an updated capacity assessment to demonstrate whether in fact such capacity has been restored and provide some kind of explanation as to why that occurred, whether it was that they've recovered following surgery or they've rehabilitated sufficiently that they're able to now manage their own care or financial decisions. And I would envision that would likely be the most common way that that issue would be addressed. But Lisa, if you have any other comments.
Thank you.
Or
No, I was just gonna say I agree with that. I think that would be it would be the same process. And if there's any dispute, then I think you have to get directions from the court. I think there was actually a recent case that touched on this. I'm sorry, I don't have the citation in front of me, but I read a case about this recently where this happened. I don't have more info though, so that's not helpful. There's a question in the chat from Adam Persofsky who asked who could ask for directions under Section 68 of the Substitute Decisions Act. And so that relates to applications for directions relating to personal care. And it's the same as for property, I believe, but it can be made by the person's guardian, by an attorney, by a dependent, by the public guardian and trustee, or any other person with leave of the court who Brad explained what that means earlier.
And my one comment about Section 68 is that the language is very similar to the language I was just talking about, which is who can compel a passing of accounts. I don't believe I've seen a case specifically dealing with Section 68, although I would presume that the analysis from the cases I mentioned earlier for who any other person would be, the test would be quite similar for the purposes of Section 68.
There's a question about who is the POA required to report to on a regular basis. I think that really depends on the circumstances, but when you consider the people who can apply for directions or passing of accounts, that there's some guidance there, but generally the family members or the next of kin or those people who are closest to the incapable, if they ask questions and they want some information, then you have to consider whether or not that's an appropriate person to report to. But I wouldn't say that there's a general ongoing obligation to report all the time, unless, of course, questions are asked, then you do have a duty to account. I don't know if, Brad, you want to add any more to that?
I think that's a fair summary. I don't think I have anything further to add to that. So there's a question that's saying, isn't it the lawyer's responsibility to determine if their client has the necessary legal capacity to execute or revoke a POA? Could you clarify how a capacity assessor would be in a position to make this determination? So the answer is yes and no, I would say. And the reason why I would say that is, yes, it's ultimately a lawyer has the ability to make the determination as to whether they are of the view that their client has capacity to revoke or appoint. Ultimately the buck does stop with them. But that's in my view, getting a certified capacity assessment, and they do have the ability to make a determination as to that very capacity assessment serves, as I mentioned before, it serves two purposes. One, if there is a fight, for example, there's a previous attorney who's challenging this change of attorneyship, and they argue that, mom's subject to undue influence and she's got diminished capacity and there's no way that she did this on her own accord. It provides the evidence of a neutral third party certified capacity assessor is going to be, in my view, more compelling to a judge than a drafting lawyer saying, yes, I determined that they had that capacity. And second, as I said before, from the lawyer's perspective, in sort of a professional liability perspective, it's a boots and suspenders type of thing. If you have all of the hallmarks of red flags, an elderly client, maybe some previous evidence of cognitive issues, that they were taken by another family member, that family member is in fact the person who he wants to name as his new attorney. All of those things can become red flags. And if it's, in my view, prudent to get a certified capacity assessor involved, because that will, in essence, provide further backing, if you decide, yes, I believe that this person does have capacity and doesn't and isn't subject to undue influence, it provides you with further protection should anybody ever subsequently challenge the fact that you did in fact take on the retainer, prepare the revocation, and prepare a new power of attorney.
Um, this is Dr. Moore again. I just want to provide some clarification. Designated capacity assessors are not trained or have not been trained with regards to identifying undue influence. They also have not been trained with regards to the granting or revoking of power of attorneys. That's just for people's knowledge base. The main training for designated capacity assessors is Section 16 and Section 20 and guardianship applications to the courts for both personal care and property.
That may be the case, but there are experts out there who will at least I appreciate that undue
Yeah,
influence.
it's true. I just want to clarify. There's a difference between getting an expert to address, but there does seem to be out there amongst lawyers and the public a blending or a misunderstanding and characterizing automatically a designated capacity assessor having a certain degree of expertise. And I'm just sort of trying to clarify factually some of how that works.
Fair enough. Thank you. Okay, I'm just going through the chat now. So there's a question about, I guess, if attorney resigns, do you have a view on whether the former attorney can revoke that resignation and thereby reinstate themselves as attorney? Um, I have not seen that specific issue arise before, but my view would be that they could not. At the end of the day, it's the grantor's determination as to whether or not they want someone to act on their behalf. So if a attorney resigns, and I'm not in this scenario, I guess there's two scenarios. One scenario would be that the grantor still has capacity. And in that scenario, my answer would be definitively, I don't believe that that would entitle you to sort of reconsider if you've already resigned. It would be up to the grantor to make that determination. And even if the person, let's assume for the moment that the attorney resigns, the grantor definitively loses capacity, I would still think that in that scenario, the attorney wouldn't be able to resume their position. They could bring an application to become a guardian, but I'm not sure. I would be surprised if a court would simply allow them to reconsider if they previously resigned. I don't know, Lisa or Yana, if you have any thoughts on that.
No, I think I agree with you, Brad. It's a very unique case. I haven't seen myself either. Somebody asked about the prudent investor rule and how it's applied to managing funds. I don't know that it makes a difference if the residual beneficiaries are charities, but maybe that's more of a question in the estates context where there's residual beneficiaries. But I think the same fiduciary obligations, if you're working with a will, then you have to work within what the will says about managing that, but that's has not related to power of attorneys or guardians. But during the donor's lifetime, someone's funds are supposed to be managed for their benefit exclusively. So I think that's the kind of overarching and operating principle.
Okay. I see a question. Can a grantor give her attorney the power to appoint an alternate attorney? I I don't I don't know definitively, but I don't think so. I think the answer would be that can a grantor give her attorney the power to appoint an alternate attorney? I'm I'm not personally aware of any scenario that I've seen or any document drafted that way, but I would be surprised if that you could simply delegate that kind of decision. I think that's sort of it's it's the antithesis of what the intention is generally behind powers of attorney, which is giving the grantor the discretion to make decisions as to who they want to deal with their finances and care and permitting. Oh, you have seen a document like that. I don't know. Lisa, have you ever dealt with that? I haven't seen that before.
No, I mean, usually there is an alternate named and that's the default. So I haven't dealt with a situation where an attorney has the right to appoint another attorney. Maybe if a POA document is carefully drafted, it's a possibility, but it's not something I've come across. I've never seen a POA that has that power.
Well, I think we're almost at the 1 o'clock hour. So I think I'm going to wrap it up now. Thanks so much to everyone who attended the seminar. Please remember that the certificate of attendance is found in the chat. We're looking forward to seeing you at our next seminar, Guardianship Applications, on November 4th, chaired by James Dunphy and Adine Wagner. And if you haven't registered yet, you can do so at the link posted in the chat. And as a final reminder, the link to the B'nai B'rith Canada can also be found in the chat in case you would like to donate. Thanks all for your time. Have a good afternoon.